Objection.
Overruled.
Objection.
Sustained.
Hello, folks. Welcome back to Sustained Overruled. I'm your host, the Anonymous Attorney. My plans for last week and this week was to follow and cover Sarah Boone's trial, but the trial has been postponed to July. So I figured we might as well just recap and bring everybody up to speed. For those who may not know, Sarah Boone is a Florida woman who's accused of zipping her boyfriend into a suitcase and leaving him inside until his TV eventually turned off. At present, she's facing second-degree murder charges for the death of her boyfriend. Sarah was arrested in February of 2020. A day prior to her arrest, she called 911 from a home and told dispatchers that her boyfriend's TV has been turned off. Investigators provided that the defendant claimed that the two had been drinking the night prior and had agreed it would be funny if the deceased got into the suitcase during a game of hide and seek. That is according to an arrest affidavit from the sheriff's office. Sarah reportedly admitted that she zipped her boyfriend into the suitcase. She went upstairs to the bedroom and awoke the next morning to find that he was still inside and unresponsive. The sheriff's office provided that Sarah's statements did not line up with video evidence found on her phone, allegedly showing a blue suitcase facing downward with the boyfriend trying to free himself. Sarah has been charged with second-degree murder charges. Under Florida law, the crime of second-degree murder is committed when a person commits either murder with a depraved mind or accomplice felony murder. Murder with a depraved mind is committed when a person is killed without any premeditated sign by an act imminently dangerous to another and evincing a depraved mind, showing no regard for human life. The primary distinction between premeditated first-degree murder and second-degree murder with a depraved mind is that first-degree murder requires a specific and premeditated intent to kill. Accomplice second-degree felony murder occurs when a person acted as an accomplice to a person who turned another's TV off, being while engaged in the commission or attempted commission of enumerated felonies. These include arson, burglary, escape, kidnapping, and the like. So what are the penalties for second-degree murder? If Sarah Boone is convicted, she could face up to life in prison, life on probation, and a $10,000 fine. Second-degree murder is assigned a level 10 offense under Florida's Criminal Punishment Code. Absent grounds for a downward departure, a judge is required to sentence a person convicted of this charge to a minimum sentence of 16 and a quarter years in prison, but may also sentence the person up to the statutory maximum of life in prison. So that is what Sarah Boone is facing. There are a number of defenses that Sarah Boone could raise, one of which is called the battered woman syndrome. In a number of jurisdictions, this is not considered a legal defense in and of itself, but may legally constitute self-defense, provocation, insanity, or diminished responsibility. Florida, however, does recognize battered woman syndrome or battered spouse syndrome. The defense will have to show that the abuse was ongoing or that it escalated. What exactly will be Sarah Boone's defense in this case?
Go ahead and call up Miss Boone's case.
State of Florida versus Sarah Boone, 2020 CF 2603. State of Florida.
Andy Cacciatore on behalf of the state.
Defense.
Frank Bankowitz.
Let's go ahead and swear Miss Boone in.
May you please raise your right hand to be sworn in?
Court procedures are so different. I wanted to say from state to state, but even from, county to county.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Morning, ma'am. Tell me your name and your date of birth.
Sarah Boone, October 10th, 1977.
All right, we're here for pretrial conference today. Mr. Cacciatore, where do you stand in preparing to proceed forward to trial?
State's ready, Your Honor.
Oh,
Mr. Banquets, where do you stand in regards to preparing
I'm
for
sorry, the
trial.
defense is not ready. We're requesting a continuance.
Okay.
We are having difficult time finding an expert who is willing to work for the JAC rates. And so I'm still, it's an essential part of the case, basically. It's never been initiated before by any of the prior attorneys that I'm aware of.
In broad terms, what's the nature, what's the
That is
field?
spouse defense.
Okay.
Torally, we have to give the state notice,
Right.
sufficient time, and name of the expert and the essential elements that they'll be testifying to.
Right.
So, Mr. Bankwitz.
Prosecution looks disappointed.
How deeply have you plumbed the depths of the pool of experts in this field to find out or find one who's willing to work for the JAC rate?
Well, I've actually talked to three, and they don't have contracts with JAC and are not willing to work with JAC.
Let's find out who Sarah Boone's attorney is, because I'd like to know if the attorney is retained, assigned, or is it a public defender. But I'd like to see, I think there was a change in attorneys here. Ah, okay. So Frank Bankowitz was appointed, okay, not retained. Her original attorney was Mauricio Padilla, who initially tried to withdraw from the case, and Boone wrote a letter to the judge in response saying that she wanted the judge to be fully aware of the magnitude of her shock and disappointment in the betrayal of Mr. Padilla, as she had not in any way by anyone being provided any explanation for the withdrawal. Padilla withdrew his motion, but then filed it once again the following month, saying that the attorney-client relationship had become adversarial. A series of public defenders were then appointed to represent Boone, with each forced to withdraw, citing a conflict of interest. That's very interesting. That is really interesting. And then Frank Bankowitz was formally named Boone's attorney on July 11, 2022, according to court records. No, the reason why I wanted to know whether her attorney is retained, appointed, or if it's a public defender is basically I was interested in seeing who was going to bear the cost for the expert that they plan on hiring. There are cases where a defendant retains their own attorney, and the court would still be required to pay for the services of an expert witness, especially in a case like this. Had the defense not sought out an expert in order to explore the battered woman syndrome defense at length, without a doubt, that would be cause for ineffective assistance of counsel.
Made some other inroads with battered woman shelters, trying to get their psychologists, who'd be willing. Problem is willing to testify, basically.
Right.
Okay. Because of the concern about the compensation rate for testimony?
Well, that's one of the things.
How did I know? Okay. How did I know?
And to be honest with you, this case has had so much notoriety.
FYI, I do not watch these clips in advance. I don't have the luxury of time.
That people don't want to be involved.
Right.
Okay. So, Mr. Bankwitz, I'm certainly willing to give you additional time
Right.
based on my understanding of the case.
And part of it is when an expert is privately retained, let's say you have some wealthy guy. Oftentimes, experts are professionals. They have a rate. When the court is responsible for paying the rate, there's there's always a cap as to the maximum that an expert can be paid. And that also applies to assigned attorneys. Right? Anybody that's not a public defender that's representing an indigent defendant or client or accused. There's always a cap as to how much they can claim for the work or services that they've provided. It would make sense for an expert not to want to testify if this trial is scheduled over a course of days or weeks and they're only getting, a small fraction of their regular fee.
Mr. Cacciatore, well, I just want to make sure everyone in the room understood that I'll give reasonable amounts of time to prepare a defense. The defendant's entitled to an adequate defense, but they're not necessarily entitled
Right.
to the exact defense they would prefer to have if resources run limited. So, would you agree that if in fact you retain an expert and they're going to opine specifically on Ms. Boone's state of mind at the time of the incident, that opens the door for the state to
Oh,
also
most
have an
definitely.
expert? All right.
Most definitely.
So that's the end of that conference. Let's take a look at this.
Back in 2020. She recorded his pleas for help and then let him die. We're going to show you this video, the video of the recording. Keep an eye on the suitcase. Very, very disturbing to
I don't know if I
watch.
can do this.
Take a look.
I don't know. I'm having a hold on. I don't think I can watch that portion. Yeah, pause. Hold on. I've reviewed enough Discovery and I've looked at enough autopsies to know what my limits are. I don't know. I do not know that I can watch this video. I don't think I can. I mean, obviously, I don't think we're going to see a body or anything. I know my limit.
Sarah.
For everything you've done to me.
Sarah.
For everything you've done to me.
Oh, hold on. Yeah, I don't know. That's very disturbing. I don't know. That's makes me want to throw up. It makes my stomach sick. In all fairness, though, I have a very weak stomach. Anything and everything can make me throw up.
Sarah.
You.
Sarah.
You.
Sarah.
Okay, yeah, that's the end of that. I'm not going to watch. I'm not going to watch the rest of that. Let me see if I can skip past the suitcase. Yeah. I'm gagging. Yeah. I cannot watch that. Makes my eyes water.
I don't even know what to say coming out of that. The man was apparently dying inside the suitcase there, and she was just recording the entire thing, and not doing anything as he continued to repeat her name. Not until the following afternoon did Boone call 911. This was in Winter Park, Florida, and tell dispatchers that Jorge Torres Jr. Was dead. Here is what she told the authorities when they arrived.
So you've had a second to kind of collect yourself. Tell it to me again. You guys were playing last night, drinking a bottle of wine,
Putting puzzles together, doing
doing
artwork.
puzzles, artwork.
I
Okay.
had a bottle of wine and then decided to play hide and seek.
Mhm.
So he gets,
What time was that? Do you remember?
I mean, I know that I was in bed probably by 12:30.
Okay.
Well, I went upstairs at least and I fell asleep.
Okay.
Forgetting that he was
So
in
you
the
guys were
suitcase.
playing the hide and go.
Yes.
And at some point you put him in the suitcase.
No, he got in the suitcase. So he thought it'd be funny to be put in the suitcase. So I was like, okay, well, I'm going to joke with you and I'll zip you up and make him, squirm a little bit, whatever it is. But then I fell asleep.
Okay.
I fell asleep.
Where was the suitcase?
Right
You
where
got
it
in
is.
Right down there.
Yes.
You zipped him in there.
Yes.
Thought he would be funny, a little.
It
joke.
was. We both were laughing about it.
Okay.
And then I fell asleep
Where did you fall asleep at?
upstairs.
In your bedroom.
Yes.
Okay.
Totally forgetting that he was in the suitcase still.
That's a lot of talking.
And then you came back downstairs.
This morning or this afternoon,
around
yes, when I got up.
ballpark, what time?
12:30-ish. But I totally forgot that he was in the suitcase. He can tell you there's a lot of things that we have been going through. Jobs,
Yeah, he did tell me.
life, all that good stuff. So I just totally
So you
forgot.
began to do.
Yeah, I guess the prosecution will need a body language expert. I cannot really make anything of Sarah's body language here.
CPR on him.
Yes. Yes.
About
And he
what time
gurgled,
this morning
like he
did you
gurgled.
start doing that CPR?
No, it was the afternoon. It was afternoon
The
because
afternoon?
I was awake.
Wait. Is she saying that she woke up, performed CPR on an unresponsive person, and stayed with the body for some time? I don't even know why she's doing all this talking.
But then I finally decided to come downstairs at like 12:30-ish, whatever it is. And I was like, I forgot he was in the suitcase and he wasn't moving.
Wait,
Nothing
what?
was happening. So I unzipped it, took him out and started doing CPR on him.
Mhm.
He was on his way over here. I called you when he got here.
Once he got here, you
Who's
called
he?
us. Okay.
And it, like,
The
air was
officer?
coming out and he was gurgling, but
Mhm.
I could just tell by looking at him.
But you knew how to do CPR. You were doing that on your own?
Yes.
Okay.
And then
All
the
right.
person that was on the phone with me also, I counted with him doing.
And he's got no medical. He doesn't take any medication.
I don't know. Like, I don't know medical wise. Like, what I know, he doesn't take any medications whatsoever.
Okay.
The only thing, like I said, I don't know if alcohol had something to do with it, but we had a bottle of wine.
Okay. All right. Here's. I want you to sit back down because I don't want
Can I
you.
have one more sip of water?
Okay, just because you mentioned alcohol, there are two things that this is in terms of forensic medicine. Alcohol and obviously carbon monoxide poisoning slows down a person's reaction. So that could play if they consume alcohol, that's something that would slow down both their reactions.
Yeah. Go.
That personal 29 residential audible 1303 Island Bay Drive.
I'll do what I can to get you a cup because I don't want you to have to keep doing that.
Maintenance should have a proper cancel the indication is the front door. Right to that person 25.
Based of this clip, I think it would be interesting to watch her interrogation tape, right? I don't know if I'm going to post it or react to it. I have a 7-hour Alec Murdaugh video that I recorded and have not been able to edit. I mean, I did spend a really good portion editing the video, but I don't know if I'm going to finish editing it. So I don't know. Let me pause on that.
The motor unit on the channel.
The cups are like right there.
Here for reporting motor
Sit
unit.
right here. Don't talk to the ex-husband right
Oh,
now.
I won't.
Okay?
I won't. Can I have a cigarette, please?
Ma'am, I can't take anything out of the house.
It's on the back porch.
Nope. All of it. It's secure. Okay. I'll try my best to get you what you need. Okay. Maybe one of these deputies has a pack from someone. Sit down and I'll try and get you what you need. Okay.
Just cut, please.
Okay. I don't want you on your feet.
Hide and seek. She didn't call the police until the next afternoon.
This is a lot. It's a lot. But we all have to remember that Sarah Boone enjoys the presumption of innocence. And it's really the prosecution's case to prove. But I have so many questions.
One bottle of wine, drinking out of the water spigot. I mean, there's a lot to take in here. Again, this is now going to be going to trial, which is why we're introducing you to this case. The sheriff's office said Boone's statements didn't line up with the video evidence that they found on her phone, which was Jorge begging for help, and you could hear him calling her name in that video. Court documents do show a history of domestic violence between the two. Both have previous arrests for battery on each other.
Okay, that's important. That's very important right there.
Boone's attorney plans to use that in her defense against a second-degree murder charge.
That suitcase video really made my stomach turn. Yeah, I feel I feel really queasy right now. Okay, let's see. Let's take a look at the letters and then let's close this thing out. I wonder if these are the most recent letters. We'll find out in a second.
Accused killer Sarah Boone sends a strongly worded handwritten letter to her public defender and judge ahead of her coming trial. Florida prosecutors say the 44-year-old murdered her boyfriend, 42-year-old Jorge Torres Jr., in February 2022 by putting him in a suitcase and leaving him there to die.
Okay, you need to stop showing this. Hold on. I cannot. Okay, I guess I'm just going to cover my screen. But, okay, this is making me want to throw up.
Had been drinking and playing a game of hide. After that, Boone says she went to sleep and woke
No, I cannot look at this. Let's just get to the letter. Honestly, I'm on the verge. I'm on the verge of throwing up. I have a really weak stomach. Anything can make me throw up.
From the Orange County Jail. The first letter came in April 2022 when Boone wrote to her case's judge about her representation. Boone argued her defense attorney did not communicate with her about a continuance in her case. More letters followed in October, November, and December of last year, with another being sent in January 2023.
That's not it.
Throughout this time, Boone November, and another being sent.
I don't know how I feel about that. I mean, she's not the first defendant to write, criminal defendant to write a judge a letter from behind bars. And yeah, that first letter, there's nothing in there that is incriminating her in any way. So let's take a look at the second letter.
January 2023. Throughout this time, Boone's representation has switched at least 4 times for both irreconcilable differences between the attorney and client and conflicts of interest. Boone's most recent letter, dated March 22nd, 2023.
Oh, this is what I want to see. Okay.
Defense attorney Frank Banowitz. The letter reads in part, quote, Mr. Banowitz, this is my 3rd letter trying to reach you over another almost 6-week period now. The same 2 phone numbers you've given me still do not work. The one number, your personal cell, goes to voicemail directly and doesn't even ring. I've had this number since you personally gave it to me back in July 2022 upon your appointment as my attorney by the court. Not working still 8 months later. The other number rings and rings and rings until it automatically disconnects me. Not working either. This is also the number you continuously tell me it just needs to be activated. Please activate. I even, in my description to speak with you, had an outside caller try to reach you on my behalf, who tried calling your office 3 times over the last almost 3 weeks, leaving a voicemail each time with no reply. We're both hoping you are able to reply to her email she sent today as another form of trying to communicate with you. I've exhausted my resources and am again just sitting here waiting for you to contact me in whatever way you are able, and as soon as possible, please. Time-sensitive matters are at hand, as I have made you aware of previously, verbally and in my letters. I know you have attempted to schedule the minimum 15-minute. At this point, there's a break in the letter. There may be a missing sentence or page. It picks back up by reading, quote, my pretrial conference, I found out, is now on 3/31/23, which you said previously for whatever reason, I'm unable to attend any of these conferences. How am I supposed to know what's going on and what you are reporting and what is being discussed between all other parties except me, the main component in my case, especially if we, in a still unestablished attorney-client relationship,
I do not know what to say.
Are not in regular or proper communications with one another? Why can I not be in attendance and participate in my PTC, meaning pretrial conference? How else am I to be kept updated in real time and actual minutes during the conference if not there myself? I have no way of knowing anything if not updated by you, my attorney, and do not have a computer to use/view myself. Help me understand, please. How can Court TV, different news channels, and even professional YouTubers attend my PTC?
Oh my goodness.
Again, meaning pretrial.
She mentioned professional YouTubers. Yeah, I mean, I should probably go out to Florida. I should probably go out to Florida and attend the pretrial conference.
Trial conference. And I cannot. How? I'm sure one of the other parties can help me with updates since they will all be in attendance for me also, should you be unable to provide. Why can I not be included in my PTC for my case? I'm sure also everything from the conference collected from everyone else will be vomited all over the internet just like everything else had been non-permissively and can add even more dysfunction and ignorance to my prejudgment already made by the world in the great court of public opinion. I'd like to be part of all this, seeing as it all pertains to me. Please, it is my right. So many questions, concerns piling and piling up from not being, and that's where the letter cuts off.
She sounds somewhat frustrated. Whether her attorney has been responding to her or not, that really depends on, it's not here, not there. We don't know. We're not privy to their attorney-client relationship. I mean, when I read the news article about her not being brought to, or her not but participating in the January 17th conference, that's it's kind of worrisome to an extent, because as a public defender or criminal defense attorney, or somebody that represents and guards the rights of an accused or defendant that's accused of committing a crime, is that you want them to be able to trust you. Okay. And if the client cannot trust you, there will definitely be a breakdown in communication. Let's see how this thing pans out. I'm curious to find out if they had made her an offer, and obviously if they if they made her an offer, she obviously rejected the offer, and that's why she's going to trial. But let's see how this pans out. I'd like to see what will be admissible and inadmissible at trial. And most importantly, I'd like to see how the battered woman syndrome defense, or battered spouse syndrome, as they use it in Florida, plays out in this case. Okay, I hope you enjoyed this video. If you did, leave a like, comment, subscribe, and I will see you in the next one.